Moving along in our discussion of child maltreatment, we're going to look back a little bit further in the child's life to the time before they are even born. Okay, so when we're talking about a fetus, we are referring to a human being that is developing in its mother's womb more than 8 weeks after the time of conception. We care about fetuses and their development because they're going to grow into the children and the people that will become our future. So, this is clear when you consider the fact that we document and report instances of fetal death. Fetal death refers to any spontaneous death of a fetus while still in utero, that as it occurs at any point during the pregnancy. You've probably heard the term stillbirth and miscarriage before, and stillbirth refers to a fetal death that occurs substantially later in the pregnancy than a miscarriage. Okay, miscarriage is much earlier. So most states do report this, but in fact, it's so important that some states report all fetal death at any point in the pregnancy. Okay, so the question then is, well, is fetal death a form of child maltreatment? It is harm being done to an innocent child that cannot protect itself. Well, because the cause of most cases of fetal death are unknown, it's pretty clearly not child maltreatment. However, there are cases where the cause is known. When a fetal death is caused by the action or inaction of a human being, then it could be by a human being other than its mother. Right? Then it could be a form of child maltreatment. Or is it just anybody? Could the action or inaction that harms a fetus by its mother, is that also fetal, or is that also a form of child maltreatment? Well, before we go any further, we have to better understand legal and constitutional rights of a fetus. Okay, and this all begins with the landmark case of Roe v. Wade. So in Roe v. Wade, Jane Roe, using obviously under a pseudonym, tried to get an abortion, but there was a Texas statute that prohibited abortions unless a doctor had given the order to save the mother's life. Otherwise, at any point in the pregnancy, that was considered, it was completely prohibited. So Jane got a lawyer. They took it to court or to the Supreme Court, and the Supreme Court was charged to answer the question: does the Constitution recognize a woman's right to an abortion, to terminate her own pregnancy? Okay, and as you might have assumed, yes, the court said yes, women do have a fundamental right to terminate a pregnancy. Okay, and that's because of our right to personal privacy that is outlined by the Due Process Clause. Now, the way they structured this is that it's not just legal outright, because the state does have a vested interest in the development of that fetus, as we've already mentioned, right? So they're balancing now the interest in the safe development of that fetus against the right to privacy of the mother. So how they determined it was that if you are in your first trimester, that the states could not impose a law that prohibited abortion at any point in the first trimester. During the second trimester, there could be the states were allowed to put some restrictions in place. By the third trimester, once the fetus has reached the point of viability, that is the time at which they could live outside of the mother's womb. Once a child reached that point, the Supreme Court said states can put whatever laws they want in place. Another key piece here is that they said the fetus is not a legal person that has the same constitutional protections as its mother. And the final, most important part about Roe v. Wade was that it determined how state laws against abortion would be examined. Okay, so remember, the Supreme Court's job is to protect us, American citizens, from the government overstepping their power and violating our rights, our constitutional rights. The Supreme Court, think of them as the guardian of the Constitution. So it is their job over everything to protect what the Constitution entails. So they establish there's different levels of scrutiny. And they determined that the strictest, most narrow level, which is this idea of strict scrutiny, is how a state would determine whether or not a law that a state created against abortion was constitutional or not. Okay, and this is because they saw weight, they saw value in the mother's right to privacy, okay, as being equal, if not greater, to the state's interest in protecting the child. So just a little bit about levels of scrutiny to clarify here is that remember that if a state government is going to impose something on you or do something to you, it has to have a reason. If the state just can't come in and say, oh, hey, we're going to tap your phones. Now, they have to have a good reason. Okay, so if they did, they could come tap your phones, right? But you could then take it to court and take it all the way to the Supreme Court and be like, look, they violated my constitutional rights. And the court would side with you because, right, they don't have a reason. Now, the more serious that they are doing, or the less desirable that the government's trying to do, the better reason they better have. And that's all this idea of scrutiny is. So because abortion laws are at the highest level of scrutiny, what that means is the Supreme Court sees the imposition as a very serious imposition with a very undesirable action, right? Like that the mothers do not want that imposition. Okay, so because of that, it requires a very good reason. Okay, y'all, I had some technical difficulties there, so I just had to cut this video, and I'm not sure how great of a job I did, so if it skips a little bit right there, I apologize. So moving along. Sorry about that, I told you. Okay, so moving along, right? Prior to 1992, abortion regulations were at the strictest level of scrutiny, meaning the woman's rights were seen as more important than the fetuses. Okay. Then in 1992, the legality changed from the trimester framework and shifted to the viability aspect altogether. Okay, so really the right to have an abortion the legality of a state's regulation on abortion depended on the point of viability. So they basically said if the fetus is not viable yet, then you're much more limited in the restrictions you can put upon your people. However, once that fetus has reached the point of viability, you can do whatever you want. Well, as medicine's gotten better, the point of viability has gotten earlier and earlier. Okay, in fact, fetuses are living outside of the womb. Well, once they become infants, are living outside of the womb at a very young age. So they were trying to make this more informed because they were trying to get women to understand that how far along they were in their pregnancy, that this was now a child that could live on its own. Okay, and the Supreme Court, or the court, ruled that the strict scrutiny approach to determining the legality of a state law was no longer applicable. Instead, they shifted it to an undue burden. Okay, and what this means is that abortion restrictions that a state creates can be understood as imposing an undue burden if it places a substantial obstacle in her way. And in the words of Sandra Day O'Connor, who wrote the majority opinion in this case, that only where state regulation imposes an undue burden on a woman's ability to make this decision does the power of the state reach into the heart of the liberty protected by the Due Process Clause. Again, remember, the Supreme Court is there to protect us. So they're saying that if the state imposes an undue burden and makes on a woman's ability, the state has violated or the state has overstepped. Okay, that is too far. So with this in mind, okay, now you're starting to have an idea of how we see them, right? Because now under Planned Parenthood versus Casey, we see the fetal rights as having much more weight, right? So whether or not a mother terminating her pregnancy or a woman terminating her pregnancy, at what point does that become child maltreatment? Is abortion child maltreatment? Well, that is a much more complicated, loaded question than is fetal homicide child maltreatment. Okay, so what fetal homicide is referring to is when a woman loses her child as a result of the actions of another person. So let's say there was a woman that was pregnant and she was shot and killed, and she was also pregnant, and the child or the fetus died. Not only is the offender going to be charged with her murder, but they can also be charged with the fetus's murder. Okay, have that in mind, the stark contrast of what we just discussed about abortion. Under fetal homicide laws, fetuses are treated as a person. And in 2005, the federal government passed a fetal homicide statute, which says that if a violent act happens, or if violence occurs and causes the death of a fetus, that in that instance, or in general, an embryo or a fetus in utero can be treated as a legal victim. Okay. What's important to note is that this was shortly after Scott Peterson killed his wife Lacey, who was pregnant with their unborn child. There was a lot of support for this movement, but placing this against the precedent set in Roe v. Wade that a fetus was not a person, but yet they can be recognized as a legal victim. How do we determine who the perpetrator has to be for that to be considered a victim? At what point is abortion no longer a woman's right to terminate her pregnancy and becomes a fetal homicide? Another important question is, what about drug use during pregnancy? Anything that goes in the woman's body gets fed directly to the child or to the fetus. So is that child maltreatment? Well, again, it certainly depends on how you define child maltreatment, but it is often recognized as such, okay? That especially when you see infants that are born with severe drug dependency that experience withdrawal in their first few moments of life. A little bit of context here. There are 3 states that have specifically mandated that substance abuse during pregnancy is a crime. However, many more states consider it to be child abuse. This is interesting, right? Because child abuse most certainly is a crime. Yet, only 3 states recognize substance abuse in pregnancy to be a crime. However, despite the fact that only 3 states have ruled drug use while pregnant as a crime, nearly all states have prosecuted women for using drugs while pregnant. This largely escalated during the crack scare of the 1980s, where there was this moral panic about crack babies being born everywhere. Okay, so think about this for a minute. Okay, if we look at our precedent, right, this right to privacy that was set up in Roe v. Wade, so much so that any law that wants to infringe on this is subject to strict scrutiny, compared to how we justify fetal homicide laws, right, in this, that you are killing a person that was going to become in this world and will never live and never be. Consider this in context with the criminal prosecution. So what I want you to do here is think about the rights of women, okay, versus who are pregnant and who are addicted to drugs, and the rights of fetuses, right? Think about what the law is trying to achieve. Why do we prosecute pregnant women? What is the goal? Does this achieve this? Does prosecuting pregnant women achieve what it is we hope it to be? Okay. Also, if we begin prosecuting pregnant women who use drugs, what are the potential negative consequences of that? What are the potential positive consequences of that? I want you to really weigh on this. Why would it be a good thing to criminally prosecute pregnant women who are using drugs, and why might it be a bad thing? Then you're going to go to the group discussion board, or the class discussion board, and ponder and answer exactly this.